Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Ted Cooperstein, an appellate lawyer who has represented January 6 defendants. He's going to weigh in on the Supreme Court's upcoming case over an obstruction charge that hundreds of January 6 defendants are facing, including former President Trump. He'll also comment on what is at stake on April 25th when the justices hear arguments from President Trump's legal team that he has presidential immunity from criminal prosecutions for acts that occurred while he was in office. He's using that claim to try to dismiss the charges special counsel Jack Smith has brought against him in Washington over January 6th. Let's first start with the Fisher case, which is scheduled for arguments April 16th. For some of our listeners who haven't followed some of this January 6th litigation closely, and please jump in here if I misspeak, okay? You're the expert. Basically, Joseph Fisher, he was in the Capitol, I think, for a few minutes. He's challenged one of the charges that he's facing, and it's basically made it all the way up to the justices. And I believe, Ted, you have some defendants who have had the same obstruction charge that they're facing related to January 6th. So my understanding, and again, you're the expert, so you tell me, it's a charge under Title 18, Section 1512, which pertains, I think, to more like evidence destruction, right? And obstruction of official proceedings. Is that correct?
Yes, it's actually entitled in the U.S. Code as a obstruction of justice statute, and it was enacted around 2002, 2003 as part of the Sarbanes-Oxley legislation, which was a response to the Enron accounting scandal, corporate accounting, white-collar crime scandal around 2001, 2002. And it's basically designed in response to the Arthur Andersen criminal case, which led to the dissolution of a large national CPA firm, accounting firm, only to reach the Supreme Court. And by 9-0 unanimous ruling, the Supreme Court said it was a wrongful conviction, but it was too late for that accounting firm. It had already been dissolved. Basically, the accountants in that white-collar case had destroyed documents. The government tried to argue that that was obstruction of justice by destroying documentary evidence, but there turned out to be a loophole in the statute at the time. The law forbade somebody to tell or influence somebody else to destroy documents, but there was no law against doing it yourself. So they amended the law with this 1512, Section 1512, to make it a crime, a federal crime, to basically destroy evidence, particularly documents, records, or any other type of material that would be pertinent and important to a criminal investigation or an ongoing proceeding. So the relevant part of that has been used for 20 years, basically what we call judicial administration crimes, for obviously destroying evidence, obstruction, but also witness tampering, intimidation, any type of thing that would affect the proceedings, usually in the courtroom. But it's written broadly enough to affect any official proceeding in the federal government. So it could also be an administrative hearing or a congressional hearing. And what we have now with the January 6th defendants is the Department of Justice has chosen to wield this statute very broadly and to say that even though they had nothing to do with a judicial proceeding or destruction of evidence or affecting witnesses in an ongoing proceeding, the people who were an unruly mob and rioted on January 6th were close enough to the congressional proceeding and arguably the cause of the recess in that proceeding that they disrupted an official proceeding, so therefore they're liable under the statute by the government's reasoning. And it's a serious charge because it has a maximum penalty of 20 years. Right.
I was going to say that. And then also it's I think that prosecutors have used it with more than 300 of the January 6 defendants, including Trump, right?
Yes, depending on which tally you look at or who you look to for your source. I believe there are a couple of press releases from the Department of Justice of the United States Attorney's Office in District of Columbia that say roughly 300 or over 200. My own calculation, when I checked the clerk of the court's office, you can go and pull things up statistically. I counted about 235, but that was as of the moment and may or may not, I'm not sure if that included cases that have already been resolved and sentenced that may no longer be
right. Tracked. So one of the things I saw too is there seems to be some judges that are releasing January 6 defendants on the condition that after the justices rule on this issue, if they were to rule against the defendant Fisher here, that those defendants would return to custody. One of the reasons I covered that is it suggests to me that there's some district court judges that think, well, the fact that the Supreme Court took this case, does that necessarily signal that they're looking to, side with Fisher here or side with the January 6 defendants and say kind of what you were alluding to, that the Justice Department has tried to stretch this federal statute too far?
Well, you can't read too much into the tea leaves of the Supreme Court. As you know, the Supreme Court decides to take cases to grant what's called certiorari and say, yes, this is worthy of our attention. We'll take the case and consider it. It only takes a vote of 4 of the 9 justices, which is a minority. So it doesn't necessarily mean that anybody's going to win. Mm-hmm. What it means is that there are at least a significant minority of 4, and there could be more, who take it serious enough to warrant a look. Mm-hmm. Now, there are those who will say the Supreme Court doesn't take cases to affirm them, because, of course, if they deny cert and just choose not to take it, then it remains as is, and that effectively affirms the lower court. But on the other hand, it's no guarantee that you're going to get a reversal. It just means that they see it seriously enough and credibly enough that it's worth asking the parties to come before them and brief it in detail and argue it so that they can make their own decision. Otherwise, you wouldn't always see 9-0 or other type of ruling. So,
Go ahead.
But what the district court judges are doing, it's really a practical and pragmatic acknowledgement of the situation. If you're in the middle of a trial or you haven't yet gone to trial, with defendants who are charged with the same statute that is under question and under review, judges are like anybody else. They'd like to avoid doing unnecessary work. So if there's a prospect that they wouldn't necessarily have to go further on that statute or they'd have to redo their work, they can control their own docket and they can say, well, we'll hold off on that. Mm-hmm. For instance, I just recently was advising and insisting in one of the criminal trials for a J6 defendant who is charged with the same exact statute. And the judges decided, well, in this case, it's a bench trial, so there's no jury. That's less complicated. And he said, well, I'm going to go ahead and proceed. But I will probably wait to see what the Supreme Court's ruling is at the end of June before I decide on that particular statute, because then I'll know exactly what the law is that I'll have to apply to the Supreme Court. So depending on whatever point in the process or posture any individual defendant's case is, the judges then can say, well, we can stop for a while. Other judges who have convicted defendants have said, well, we've convicted you, but we'll hold off on the sentencing, because they can always continue and postpone the sentencing hearing until they see what the Supreme Court does. Because obviously if that necessitates an adjustment, they'll do that.
I think there was one guy that I covered, and I think it was like misdemeanor charges and then this one. And so I think the judge said that I think it's like after the end of May, he can be out, while the justices, I guess we expect them to rule by the end of June, since that's the end of the term. But basically that end of May is when his misdemeanor time would be up. So then, I guess depending on what happens with the felony charge, he might have to return back depending on the outcome of the case. And
again, like I said, this is a practical consideration, because even if you recall during COVID when there were lockdowns and a lot of slowdowns in trial courtrooms across the country, many courts that found that they had a backlog of trials and they had to keep continuing cases until getting through the pandemic, started paying attention, very close attention, where they had somebody who might be detained pre-trial, which of course counts towards your ultimate sentence if you are convicted. Mm-hmm. And then when I was in the prosecutor's office, they would continually ask us to keep them updated in case somebody was approaching the limit of the maximum term they would get if they were convicted, so that they would keep nobody over that time period and unjustly jail them beyond what they could get even if they were convicted. So it's something of just a logistical management. But unfortunately, as you'll see in the case law, both state and federal, sometimes people slip through the cracks and wind up staying a little longer. I've seen some cases, I think, reported out of Louisiana where there was some slip-ups in some county jails and people were being held over their time because of miscalculations or forgetfulness or bad record keeping. So this is a constant concern whenever you have people in jail.
Mm-hmm. And then I guess So what happens, like, if the justices do rule for Fisher, like some of these defendants? What about the ones that have already pled guilty?
Well, Fisher himself, I think, is still been convicted on other counts.
Right.
So it's not necessarily a clean break or a full clean bill of health for any particular defendant, even all of them. But somebody who may have, for instance, like you said, that other example with just a misdemeanor charge and this one serious charge. Well, if they strike down or say this just doesn't apply, then that person will hopefully be done with the experience and just have the misdemeanor.
Right, so they could get out earlier, for example.
Well, yeah, if they're already in jail. Other people who are still pending, it affects the calculus on plea negotiations.
Mm-hmm.
So if this one major 20-year maximum felony is the club that the prosecutor is wielding to try to leverage a plea, they'll be bereft of that, and so you have to go back to the table and decide, well, what can they do to avoid the expense and the time of trial. As far as people who are in jail, if they've started serving their sentence and they're already convicted, if they filed an appeal, once a conviction is on appeal, it's still not technically officially final. So anybody who's on appeal to the Court of Appeals would get the benefit of any change in the law or new opinion from the Supreme Court. So that would be sent back to the Court of Appeals, who would presumably say, yeah, we have to adjust or strike this particular 1512 charge accordingly.
Mm-hmm.
And that also applies to people who may have lost in the Court of Appeals in D.C. but are pending their own review in the Supreme Court. For instance, you may recall that Mr. Fisher was one of three people who were consolidated in the U.S. Court of Appeals. They were each individually charged, but they all had the luck of the draw to be assigned to the same district court judge, Judge Nichols, who initially wrote the opinion saying that 1512 was being improperly used against them. When each of them, when the government then specially took a appeal to the D.C. Circuit, in each of their cases, the D.C. Circuit realized it was the same reasoning from the same judge in each three, and they consolidated it into one appellate case for the hearing. And I mention that because each of the three separately petitioned the U.S. Supreme Court after that D.C. Circuit ruling. And the Supreme Court chose to grant a hearing to Mr. Fisher's case and not yet to the other two. The other two are held in limbo. They still have a petition pending, but nothing has been done on that. And that's typical when there are multiple appeals or petitions to the Supreme Court on the same issue. The Supreme Court can basically pick and choose what they think is the best or most appropriate vehicle to hear the issue. And then the others would be sort of held in abeyance. And once they have an opinion at the end of the term for Mr. Fisher, there will be you'll see some quick orders on the docket, probably saying that they'll either grant or deny the certiorari and return it to the Court of Appeals for proceedings in accordance with whatever opinion and decision they make for Mr. Fisher. So that's pretty much the status on where things are.
How big of a, blow to the Justice Department in their January 6 prosecutions would it be if they were to lose this case?
I think it would be significant public relations blow. And given that they've been relying so heavily and broadly on this strong statute to really go after each of the January 6 defendants, it really does take a significant weapon out of their arsenal.
Mm-hmm.
As would happen in any prosecution, when you suddenly lose a statute that you're relying on, you have to go back to the table and recalculate. And of course, it affects any new indictments going forward. You've seen that recently in the last couple of weeks. There's been a tell of a new wave of arrests that they're still going after and finding more people that they want to charge.
Mm-hmm.
And this is going to affect the calculus going forward, as well as reassessing where they are in the cases that have not yet gone to trial. And then they'll have to deal with whatever post-conviction motions and litigation could be engendered by the first ones to be.
And what do you think about with Trump? I mean, because this is one of 4 charges I think Jack Smith has brought against him.
Yes, you mentioned that. And specifically, he's got 2 counts in I think it's the Washington, D.C. indictment. He's charged with the same statute, 1512 C2, claiming that he personally was involved in obstructing the proceedings of Congress. But they've added another subsection, or rather, there's another part of the statute that they've charged against him, adding yet another count to his indictment. That's specifically 1512 subpart K, and that is the organic conspiracy provision that it's saying it's just as equally a crime up to 20 years imprisonment for conspiring to violate 1512. So they're claiming that he got together with an unlawful plan in concert with other co-defendants to perform the acts that violate, according to the government, 1512. That's half the indictment that goes away.
That's what I was about to say. So it wouldn't just knock this one charge; it could knock two.
That's right.
Interesting.
Conspiracy is dependent on the substance of what you're conspiring to do.
Mm-hmm. And not to mention, you said like a bad PR for not only the DOJ but Jack Smith specifically with this one, especially since all the coverage it's getting. On the topic of Trump, I know you have January 6 defendants that you've filed in the Fisher case or along the obstruction charge, but on his immunity claims, the justices were going to hear that on April 25th. I'm kind of going to just pick your brain there. The D.C. Circuit had ruled against Trump unanimously. Basically, his lawyers have argued that he can't face criminal prosecution for his official acts while in office, and that to allow a president, I guess, to face these charges, I could create, and I don't want to like dumb it down too much, but basically like a political tit for tat, right? Like the next DOJ could come after a prior president, or like the Obama DOJ could have gone after the Bush DOJ. Is that the President Bush? Is that kind of like what their main argument is?
It certainly is part of the argument, and it goes to the fact that you're not only dealing with people trying to convict Donald Trump and he defending himself. There are also people who are trying to defend the institution or the office of the presidency, no matter who would be occupying it in the future. Because when people get so blinded in their political animus that they want to go after a particular president like Trump, they really have to be careful to watch out for the unforeseen consequences down the road, that it's going to diminish the office and make it more difficult for others, and it could open the floodgates to, like you said, tit for tat, wave after wave of recrimination. That's why some people really worry that we appear to be becoming a third world country with this type of political vendettas and weaponizing the justice system.
Right. And what do you make of his arguments? I mean, do you think that I'll phrase it like this. So I covered the Supreme Court since 2017, and sometimes when I see them take certain cases, like especially like political ones, like the Trump ballot case, they had a unanimous ruling on. Do you think that this is something that they would try to speak as one voice on, or do you think that this could be something that they do kind of like maybe a Roberts type ruling where they try to find like a middle ground and say, well, maybe these are the tests that the lower courts have to look at on each charge to see if it's something that a president could face? Like, do you have any sort of grasp on where you think how this could play out?
Not too precisely, and certainly with no guarantee of predictability, but I do believe the justices take this very seriously, as they should. It's not only a high-profile matter that they really can't avoid getting involved because it requires some clarity. It is really the first time that this has happened in the legal system. And as we just said, it's very fraught with the danger of becoming a recurring pattern of recriminations in the future, that it needs to be carefully described and circumscribed, if not nipped in the bud. There is, thankfully or fortunately, some partial precedent, at least some help. It's not totally unforeseen in that there were civil lawsuits brought against previous presidents, principally Richard Nixon. And that is in part what the Trump defense and those who are friends of the court on his side are pointing to, is the fact that there was the precedent. There's a case called Nixon versus Fitzgerald, where people had tried suing then President Nixon and afterwards former President Nixon civilly, trying to claim that he violated their rights and whatever policies or actions he may or may not have taken while he was president. And the Supreme Court, I don't recall if it was unanimous, and it may not have been, but it was significant enough that the Supreme Court analyzed it and said, we really can't have presidents held liable this way for important decisions that they may have to make under pressure and short timelines, and we just can't afford to shackle or tie their hands behind their back with this fear of litigation. So they basically said there was effective immunity for those regular decisions that presidents have to make. Now, that's not to say that presidents can't be held accountable if they exceed their powers or their authority, but it's a fairly strong precedent, and it's along the same lines of what you may have heard or discussed before, the issue of qualified immunity for many public servants and government employees that if they're basically going about doing their job and they're not aware or have no reason to believe what they're doing is wrong or unconstitutional, they're generally going to be given a break in the judicial system by what's called qualified immunity. Now, that itself is controversial as well. A number of people who look at these things, and that's usually like suing the police officer who seizes authority, busts down your door, or gets arrested the wrong person, or goes to the wrong house. But there are many other ways, and that's always just sort of an evolving body of law, because the standard there as well was it a well-known principle that you just can't do that when you're a well-trained police officer. You should know. So many times I'll hit something and say, well, he didn't know now, but everybody should know going forward. With presidents, however, it's a bit more emphatic or absolute. Just as with judges, judges have absolute immunity. You can't really sue a judge if you don't like their ruling. The president, again, as long the assumption is as long as they're doing their job within the confines of what everyone understands to be their job, then they really are protected and should not be held accountable. Now, they're looking to extend this principle to say, look, if anybody's so bold as to think they can actually indict him with the powers of the government, they really shouldn't be able to do that because, as you said, it really turns the government in against itself. And how is any president in the future going to be able to comfortably exercise the powers in the office and do what he feels best for the country if he thinks that the next guy's going to come after him?
Right. Let's say, hypothetically, if the court were to deliver a ruling in favor of Trump, could this impact some of his other cases that he's facing, some of the other prosecutions? Like, I know there's the case down in federal court in Florida over the documents that, of course, was, I guess you could say, like actions he took as he was leaving office. But I'm just kind of wondering, like, also with some of the state prosecutions, Georgia, New York, like, if you can't prosecute a president, how widespread could a ruling in his favor be? Does that make sense what I'm trying to get at? Like, could it affect some of these other cases?
There could be quite a ripple effect. It certainly would apply to a federal criminal proceeding in the Florida District Court. There, the question would be how broadly will the Supreme Court rule, and would it have a dividing line as to when he left office at noon on January 20th? Does it mean everything before noon on January 20th is protected, but everything afterward is not? Or is it going to be broadly written to say, the president is the president, and even former presidents should have the same protection, so we really can't see allowing you to prosecute somebody for the consequences of their actions while they're in office. As for the state court, it's interesting because you have this thing called the Supremacy Clause in Article 6 of the U.S. Constitution that says state courts are bound by the rulings of the federal courts and the Constitution, of course. Then you probably have a little bit of litigation as to, well, what does that mean in the context of each particular case, and would that then put the state law in conflict with the federal law? And so you may have some federal courts, lower federal courts, hashing that through and working its way up to the Supreme Court for yet another round to say, well, now what is the effect on the state courts? Certainly you'll see people wielding that as an argument to say even if it doesn't directly apply, it's the equivalent principle should be applied by the state court in their own courts, in their own jurisprudence.
I guess what the Supreme Court does it depend on the ruling if we're going to see some sort of delay? Like, one of the things that keeps happening on social media is people are so outraged that there hasn't been a trial or there's no trial date with Jack Smith in either the Florida case or, what's happening with the D.C. election case. It's my understanding usually it takes years to go to trial. Like, it's not, something that happens this quick, and it just kind of seems like people want it faster because it's Trump or the election. Could there be, is this first step with this ruling we'll have from the Supreme Court, is there going to be further delay from that? Like, do lower courts then have to go through and apply it? Like, how does that work? Does it depend on the ruling?
Well, there's obviously the delay in waiting for the Supreme Court to rule. There's a certain delay procedurally in that when the court issues its ruling, it worked its way up through the courts of appeals to the Supreme Court, and it's going to go back the same way. When the Supreme Court decides a case, it goes back to the Court of Appeals or the state Supreme Court where it came from. And they will have to enter or adjust or modify their own, what's called the mandate, their formal ruling, and then send it back down to the trial court. So there's going to be a necessary inherent procedural delay involved in that. Then you're going to have the trial judge wanting to take some time to read the opinions from both the Supreme Court and possibly the Court of Appeals, and then try to make sure that she knows how to apply it properly and is following that, because they have the obligation to follow those appellate rulings. And that may lead to giving both sides time to brief it and argue about it and say, now that we've got these opinions, what does this mean? Of course, both sides will have a different take on that. And that's all part of having due process in the adversarial justice system. So the people who are just too impatient and want to hang them now and have a trial later, I'm sorry, it just doesn't work that way. Although if they have their way, maybe it will. And that would be a real loss for all of us.
And on that, have you ever, I guess, like, first of all, correct me if I'm wrong, it's usually not, you don't see a trial, especially of this magnitude with felony charges, go to, usually it's like a year or more, right? Like, I mean, am I wrong that to like think about the idea that some of these people think that he should already be, going to trial? Like, I just find that surprising.
It depends on the evidence.
Mm-hmm.
If there's an awful lot of documentary evidence, and I used to see this as a former prosecutor in white-collar crime cases, if what you're trying to prove in the charge is largely document-based, well, you have an awful lot of that to go through, and then you have to turn it over to the defense, and they have to have time to go through and look at it and analyze it and decide it. And they may ask for more, or it may be that the prosecutor only turns over what is necessary and essential to their prima facie case, their basic elements that they need to prove, but there may be other things that the defense may want to say, yeah, we see what you're doing here, but we think there's more that you have that you can show us on this area and that area that's related, but perhaps not in the immediate focus, and it goes to maybe potential defense they want to raise. So they have a right under due process to see all of that, and that necessarily takes time. Now, the official timeline under the Speedy Trial Act, when somebody is arraigned on their indictment, they have to go to the trial, all other things being equal with no motions or other reason to do otherwise. The trial should be set between 30 days and 70 days after that arraignment. That way, the defense is given that basic 30 days to prepare a defense, and if somebody is anxious to go to trial and get it over with, they can insist on their right to speedy trial and force it to go to trial then.
Mm-hmm.
Otherwise, trial courts are quite anxious and diligent, and they usually will enlist the prosecutor's office to help them to keep track of that 70-day time limit. Because if somehow or other things go past that 70-day time limit and the defendant has not waived his speedy trial right or otherwise agreed to an extension or continuance, then that's grounds for dismissal of the case.
Mm-hmm.
Now, it won't keep them from re-indicting and starting over, but it's something that both courts and prosecutors want to avoid, because if it's close to the statute of limitations, they could lose the case. Otherwise, it's just an embarrassing black eye. And the courts get annoyed because they don't like that to start things over. Every court, ever since 1789, has always felt that it's been overlogged and overburdened with too much of a caseload. So judges are always concerned to keep things moving smoothly and avoid backlog and waste of their time.
And on the doc, you talked about the number of what the evidence is, like lots of documents. With the document case, the classified document case, you would think that would take a lot of time for review, correct?
Absolutely, especially since if things are purportedly classified, there are all sorts of security restrictions and procedures to go through to make sure that it's safeguarded, not disclosed to people who don't have a security clearance. And sometimes you'll have some side issues as to whether or not certain lawyers or staffers can get a clearance if they don't already have one. Or sometimes in other cases, we've seen this since the 1980s, and since whenever there's, say, espionage or abuse of classified documents type of prosecution, there are times when the government, intelligence community, CIA, or somebody may say to the Department of Justice, listen, we really just don't want to see this classified thing released. And if it's essential to the making the case, then they may have to go through what's called the CIPA, C-I-P-A, which is the Classified Information Procedures Act, that talks about what can and can't be done to allow the defense to see things and what things the defense can demand in terms of classified materials. And there's always an option that the government can finally say, well, we checked with the intelligence agencies and they just don't want us to let this out, so we're going to have to drop that count for want of ability to disclose that. So that's always hanging over in the background, or hanging over the heads of the prosecutors too. In this case, in the Trump Florida case, it's particularly salient because a lot of the issues, whether or not things actually were ever properly classified, or B, any longer classified by virtue of the president's authority. A lot of people don't realize, and part of what's going on is there's this attempt by the big administrative state and the vast bureaucracy to say that they know better than the president and that they have authority greater than that of the president, which is absolutely absurd in terms of the Constitution, Article 2. The president is the chief and commander-in-chief and head of the executive, and anybody who exercises authority to classify or declassify is always doing an express delegation of the powers of the president. So the president is ultimately who they're supposed to answer to, and who's supposed to have the final judgment as to what is and is not classified. And that's part of what's sort of the tug of war between the institutions, again, beyond just Trump as a person, but the powers of the office and the institution going forward. Is the office of the president going to be the final arbiter, or is the bureaucracy going to have their way with him?
Mm-hmm. I guess my last question is, I guess from what you're saying, I kind of gather that you're not surprised that there hasn't been trial dates set with the Florida case, or even the election-related case in Washington, given the procedural issues there. Why do you think Jack Smith is pushing so, in your experience, is it normal for prosecutors to want to rush to trial like this?
I've only seen it in cases where you're worried about the statute of limitations would be stayed once you have an indictment. But more often than not, it's really a question of either a defendant or witnesses or something that might be time sensitive. If we had a key witness who may be on his deathbed. Otherwise, I can't really be thinking of any other case I'm aware of where you would really want to rush things like that.
I guess my question is like Smith acting, I guess, differently than, I guess, the norm because it's Trump, because of the election? Like, what do you make of?
It certainly seems that way. And a lot of the talk in the opinion circles surrounding this issue seems to support that.
Mm-hmm. Okay. Well, anything else I should have asked you? You've been very generous with your time.
One very interesting issue that I'll be curious to see if the Supreme Court addresses with regard to the Trump case. And that is, you have former Attorney General Ed Meese, together with some law professors, Stephen Calabresi is the principal one, have at repeated junctures in the case, both in the D.C. Circuit and now again at the Supreme Court, both at the cert stage and now in the merits brief. They have persistently filed briefs asserting that Jack Smith's appointment and his power to act as a prosecutor are invalid, that he is not properly a constitutionally appointed officer, and that the entire indictment and prosecution is invalid because he is not properly delegated the authority of the United States and the Attorney General to prosecute. And that was very interesting. Yeah, an interesting issue. Go ahead.
Yeah, I remember that didn't really come up during oral arguments at the circuit court level. I think that one of the judges did ask Trump's lawyer about this, and they said, obviously, it's an interesting argument. They weren't prepared to make it, but
right.
We could.
Well, they didn't have to because the Attorney General Meese and Professor Calabresi had already done so and done so very well.
So, the question, I guess, is because Jack Smith was never confirmed.
Well, yes, he's not an officer who would be appointed by the president, confirmed by the Senate,
mm-hmm.
and the way he's just there by virtue of a sort of administrative regulation by the Attorney General Garland within
mm-hmm.
the DOJ.
Yeah, I think he was like living abroad, wasn't he? Doing private work?
Oh, he was. I believe he would have left the Department of Justice. I don't think he was a justice employee anymore, but he was a appointee to I think it was the International Court of Justice in The Hague, or it may have been one of the international criminal tribunals, maybe for Yugoslavia or Bosnia, or one of the other international war crimes tribunals. And
mm-hmm.
Depending on who you talk to, that's either a serious and impressive position or it's a boondoggle.
Mm-hmm.
But he was a career federal prosecutor, so he had the resume to take that job. But the question is this really an appropriate, or just there even such a thing as a special prosecutor? We used to have the statute for the independent counsel, such as Ken Starr and others, and the Democrats used it effectively to go after every Republican president, and then once the Republicans figured out to use it against Bill Clinton, everybody decided to let it lapse. And there were serious questions about the constitutionality of that. Justice Scalia wrote an excellent opinion about it. But there is no statutory created office. It's just a little regulation in the Code of Federal Regulations for the Department of Justice that says the Attorney General can appoint someone. And that's contrary to all the established experience in the last 250 years of having United States attorneys appointed by the president, confirmed by the Senate, and otherwise subject to the control of the president. And there's a strong argument that that is the only way to effectively wield the executive power of prosecution under Article 2. So the professor and the former attorney general have both made strong arguments on this case. The D.C. Circuit, technically, in the correct sense, said, well, nobody really brought that up in the district court. It's not before us, so we're not going to bother. And also the posture of the case, because it was what's called an interlocutory appeal. President Trump brought the appeal on the immunity issue before there's been a trial, as you've noted. And in a criminal proceeding, you rarely get to bring an interlocutory or early appeal before trial. And most trials, you have to wait until the end of everything before you can take it up to the appeals court. But because an immunity claim is the basic saying that I am entitled not to have to even go through trial, to endure a trial, and that there's a right not to be tried, well, you have to decide that before the trial. Otherwise, it's a meaningless claim. It'd be ironic to have to go through trial and then prove that you didn't have to.
Mm-hmm.
So that's why it was on what they call the interlocutory proceeding. And they said this isn't something that we can independently justify under the interlocutory reasoning. You'll have to bring that up another time in another place. But now that they brought it up in the Supreme Court, if they decide that it's a jurisdictional issue, the courts can always decide jurisdiction, and it's not so constrained. So the Supreme Court, or at least one justice, may be interested enough to rule on that. I don't know if we'll get 5 justices to rule on it, or if you'll just see it in.
I suppose it's one way they could say they could wash their hands of it, right?
Well, yeah, they may not be able to address it if they want to get together sufficient votes for a majority opinion, but then that means that somebody in the concurring opinion can go into a little more detail and say, yeah, we didn't decide on this as the crux of the matter, but while we're at it, this is a serious issue too.
Mm-hmm. Well, thank you so much, Ted, for taking time to chat with me about this. I really appreciate it. I guess we'll expect rulings by the end of June, and I'd love to hear your thoughts once we get those.
Anytime. Happy to talk to you.
Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to the podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.